Bismillahirrahmanirrahim. Alhamdulillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh to our beloved lecturer, Dr. ROSLEE, and our classmate, and very good days to Mr. Pradeep and Mr. Utaya Kumar. Today, our groups from Group 4 will present our topic with client rights and counselor responsibilities. This topic prepared for Dr. ROSLEE AHMAD, who's a senior lecturer, who's a registered counselor with KBPA, lecturer of counseling program, Faculty of Leadership and Management, University Science Islam, Malaysia. Okay, about my part, Asma binti Ahmad, I will explain about what is involved in the informed consent process, describe the basic content of an informed consent document. Third, understand a counselor's responsibility in record keeping. Fourth, explore ethical issues and relate to online counseling. Five, identify some legal issues and risk management strategies for providing online counseling. Okay, first of all, I will explain about introduction. Okay, we all has a professional counselor who practice counseling should not only attain or learning the knowledge and skills of individual counseling, groups, marriage, family counseling, and possessing certain personality traits and values, but it is also essential for them to be guided by the code of ethics that had been set forth in the counseling profession in Malaysia to carry out its duties in a professional and trustworthy manner. Okay, ethics in counseling actually it identified has a set of guidelines to be followed and used to assist professional counselors is carrying out their duties under the established rules. Ethics actually in history comes from the Greek ethos, which leads to the understanding of law, customs, moral values, and custom. According to Francis 2009, this ethics actually plays an important role in carrying out tasks in the workplace to guide individuals to achieve the best professional level. Third, ethics is also a set of rules that play a role in controlling the behavior of counselors to become a more professional person based on the aspect of the responsibility. This is the value and guideline that the counselor must adhere towards their respective duties. Okay, next, in the counseling service, there are some ethical codes that have been used as guide and reference as the Code of Ethics outlined by the American Counseling Education 2014. Normally, every country has an ethical code in the practice counseling carried out in that country. As an example, in our country, the National Council of Counsellors or in Malay, Lembaga Kaunselor Malaysia, plays a part in issuing ethical codes and counselling principles which everyone who appears in counselling profession in Malaysia must adhere to. The Code of Ethics in Malaysia emphasizes the aspect of professional counsellor practice and emphasizes on the welfare of clients, counsellor and clients. Okay, all aspects of client confidentiality and privacy are maintained to ensure that clients take weight within the context of the client's own right. Based on the Code of Ethics of Malaysia counsellors must act according to law, ethics and moral values in carrying out professional work as a counsellor. Okay, the counsellor also need to be aware of the client trust, which actually of the level of professional counsellor behavior. Okay, the first about counsellor and client, informed consent. The informed consent. Okay, first about informed consent is involve the right of client to be informed about their therapy and to make autonomous decision pertaining to it. The second is both an ethical and a legal obligation of the clinician. Third, no meets legal and only ethical standard but represents excellent clinical care as well. Fourth, requires that the client understand the information present, give consent voluntarily, and is competent to give consent to treatment. Fifth, a process that continues for the duration of the professional relationship. Okay, content of informed consent have about 12 contents. The number one is the therapeutic process, including assessment. Second, background of therapist registered, certified or not, registered counsellor or not. This is important, even at Malaysia now. Okay, the number three is cost involved in therapy. Cost involved in therapy mostly in private counselling or private personal counsellor, not a government service. Okay, next, the number 4 about in content of informed consent. The length of therapy and termination time limitation have time limitation. Okay, the fifth, consultation with colleagues. Okay, the sixth, interaction in therapy. Next, about content of informed consent again. 7, benefit of risk of treatment. 8, using telecommunication technology. Number 9, alternative to traditional therapy. Okay, the next one is tape recording of video taping session. Must inform consent from client. The 11 is client right of access to their files. Okay. The 12 is rights pertaining to diagnostic classified. The number 13 is the nature and purpose of confidentiality. Okay, the next, the second one is about record keeping. Okay. Record keeping. First, from a clinical perspective, Second, from an ethical perspective. Third one is from a legal perspective. And the number 4 is from a risk management perspective. Okay. Look at from a clinical perspective. Record keeping provides a history that a therapist can use in reviewing the course of treatment. The second, from an ethical perspective, record can assist practice in providing quality care to their clients. Okay, the next number 3, from a legal perspective, state or federal law may require keeping a record. Many practice or counsellor believe that accurate and detailed clinical or safety counselling record can provide an excellent defense against malpractice claims. Okay, the number 4 is from a risk management perspective. Keeping adequate record is the standard of care. Must follow the standard of care. Okay. What is a content for inclusion in records? Okay. First, look at the client identifying her or his data. Second, client chief complaint. Third, physical exam objective finding. Fourth, intake sheet. Okay, next, look at documentation of referral and informed consent. Okay, this is important too. What a content for inclusion in records. Number 6, finding from consultation, referrals, diagnosis, procedures, and terms. Okay, the number 7 is diagnosis and prognosis. 8, treatment plan. What is a treatment plan? Okay. The number 9 is sign and date progress notes. The number 10, appointment dates, times, and types of service. Must write down this part of content for inclusion in records. In our records has a counselor. The number 11, termination and discharge summary. The 12, release of information. Okay. In securing records, first one, counselors have the responsibility for storing client record in a secure place and exercise care when sending records to others by mail or through electronic means. Second, helping professionals who utilize the cloud has an off-site storage tool may be exposing themselves and their clients to unforeseen risks. Okay. Next, about ethical issues in online counseling. Nowadays, online counseling is very famous and many people need online counseling, especially when we are in COVID-19 pandemic all over the world. But this is we will discuss about ethical issues in online counseling from the what is that? Yeah, okay. It is the counselor's responsibility to examine the ethical, legal, and clinical issues related to online counseling. Basic issues such as self-disclosure, confidentiality, boundaries, and your relationship can take on unexpected shapes in online counseling. Okay. What mistake of omission in online counseling? First, obtain informed consent prior to service. Second, limit access to personal information. Third, obtain a clinical license to practice in the state in which the client resides. Fourth, comply with HPAA confidentiality requirement. Fifth, respond in a timely manner. Sixth, terminating online service to client abruptly. 7. Claiming expertise in providing online service outside the scope of one's education and training. 8. Providing online service to clients whose clinical needs are so that they require in-person service. Okay, this is about 8 mistakes of omission in online counseling. So, but however, we can look at to some advantage of online counseling. Okay, number 1, reaching clients who are reluctant to participate in face-to-face therapy, as well as those who have certain disabilities or chronic illness that render them immobile. This is a advantage lah, online counseling. The second, improving client access in rural areas. Wherever they are, they can get their counselors, they can get their therapy, their session counseling, wherever they are. Okay, the third, the potential for greater numbers of people to receive service. Now, wherever people can get access online counseling, so that the potential for greater numbers of people to receive service become more clubs, more participants. So counseling with counselor with a client from the various background have a benefit lah, to get benefit. Okay, but there is some disadvantage of online counseling too. Okay, we look at to our presentation today. What a disadvantage? Okay, number 1, danger of making inaccurate diagnosis. This one. The second, compromising confidentiality and privacy. Maybe a client not issue lah like that. Okay. The number 3 is difficult in protecting client in crisis, because not to face to face. We don't know how about the real client's feeling, behavior, cognitive. Okay, this is the adventures lah, more adventures. Okay, the number 4 is challenge of working through transference and counterference. 5th, lack of competence and danger of the mispresentation of a counselor's qualification. Okay, this is my attachment. I am Cikgu Asma, have a website counseling online, cikgucounseling.com, but after that I just I did counseling.com with Joomla and WordPress. After that I just free hosting only, blogspot only, that is cikgucounseling.blogspot.com, for my student to transfer about counseling information, such as how to attend interview, how to fill the form UPU online, and others. This is I made it for my student, but mashallah, after that the visitor is came from all over the Malaysia student and background people, and all over the world too. Okay, this one is about, I want to share about this video too.
Sokongan dalam konteks kaunseling, dan ini kita akan terus laksanakan. Selama ini setiap sekolah mempunyai guru-guru kaunseling yang akan membantu murid-murid dalam apabila mereka menghadapi kesukaran atau perlu merujuk kepada pihak sekolah dalam suasana ataupun dalam keadaan tertentu. Guru-guru juga mempunyai ruang untuk melalui proses kaunseling jika diperlukan. Selain daripada itu, kita ada juga konsep bimbingan rakan sebaik.
Okay. The last about my past, I will explain about legal issues and regulation of online counseling. First one, a clinician or counselor license is attained for practice in the state where he or she is licensed to practice. In Malaysia, we have a Lembaga Kaunselor Malaysia under Kementerian Pembangunan Wanita dan Keluarga Malaysia. Okay, the second one is counselors need to stay current regarding the changing laws pertaining to counseling across states. Okay, the number three, at US and UK, malpractice insurance carrier may not plan to cover out of state counseling, but in face-to-face, they got the client got insurance. But however, in Malaysia, insurance carrier may not plan to cover out of state counseling, offline or online. This is at Malaysia. Okay, the number four. Oh, before I go to number four, maybe who our friends who endorse who sell insurance can introduce about counseling, client counseling, or client in secretaries can get insurance claim. Okay, the number four, licensing boards have a legal mandate to protect consumers who live in their state. They do not have an obligation to consumers who do not reside in their states, include at Malaysia too, as a lembaga council that did. Alhamdulillah, I has a registered counsellor with a lembaga counsellor Malaysia, and a member of PEKAMA International. There are very much benefit if counsellor or counselling practice who registered has a counsellor registered with Lembaga Counsel Malaysia. So many benefit you can got out and join a PEKAMA International. Okay. Option 5, the last. If a California consumer is a traveling, this is at US situation, yeah. If a California consumer is traveling to another state and wants to participate in counseling through telephone or online, the California licensed therapist must receive permission from the temporary location. Okay, that's about at US lah. Okay, this all about my past. I will Alhamdulillah, I can, my part is it here. I want to apologize from, my lecturer, from our lecturer, Dr. ROSLEE, AHMAD, and my classmate if anything wrong with me. Okay, my friend will continue, inshallah. Welcome to my friends to continue our presentation. Assalamualaikum warahmatullahi wabarakatuh and good days all.
First presentation today. Assalamualaikum warahmatullahi wabarakatuh and good evening to Honorable Lecturer Dr. ROSLEE bin AHMAD and my teammates and also all fellow friends. Today my part for presentation is consists of two subtitles. The first one is working with children and adolescents, and number two is dealing with suspected unethical behavior of colleges. Let's take a look at the first subtitle, working with children and adolescents. Children and adolescents and clients, counselors who work with children and adolescents under the age of 18 may experience conflict between what they consider to be their ethical or moral obligation and what the law dictates that they must do. And number two, children and adolescent clients, these conflicts often concern confidentiality of client disclosures made during counseling sessions. The legal perspective is that counselors are obligated to parent or guardians when counselor minor children. Every child, regardless of age, has an ethical right to privacy and confidentiality in the counseling relationship. And number three, ethically conscientious counselors work hard to respect the rights of minor clients to control access to information divulged during counseling to the extent that this is possible. This is important to remember that confidentiality is not absolute for clients for any age. One legal consideration that limits the confidentiality and freedom of choice are both predicated on the ability of the client to give voluntary informed choice. Legal and ethical questions faced by human service providers, this is referred to the counselor, who work with children and adolescents include the following. The number one, to what degree should minors be allowed to participate in setting the goals of therapy and in providing consent to undergo it? The question number two, what are the limits of confidentiality in counseling minor? Will you discuss these limits with minor clients, even though a parent or guardian consents to treatment of the minor? The number three, what does informed consent consist of in working with minors? We consider some of these questions next and focus on the rights of children when they are client. This is a parental right to information about a minor's treatment. Firstly, parents or guardians generally have the legal right to know the contents of counseling sessions with their children. This is from Remley and Hurley 2014. The number two, informed consent of parents or guardians may not be legally required when a minor is seeking counseling for addiction to dangerous drugs and narcotics, for sexually transmitted disease, for pregnancy and birth control, or for examination following alleged sexual assault of a minor over 12 years of age. This is from Lawrence and Copius 2000. And then the justification for allowing children and adolescents to have access to treatment without parental consent is that some minors might not otherwise seek needed treatment. This is a school counseling and parental consent. The number one, a counselor working with minor must know the laws in their country and understand the policies of the settings in which they work. The number two, the handbook is often sent to parents at the beginning of school years to provide them with school rules and policies. At the end of the handbook, there's typically a page that asks for parents' signatures indicating their concern for their children to use the service provided by the school, such as this is mean the securing a requirement concern. This is seeing minors without parental consent. Counselor faced with the issue of when to counsel minors without parental consent must consider various factors by the following. The question must ask is, what is the competence level of the minor? And then what are the potential risks and consequences if treatment is denied? How serious is the problem? And then if a practitioner needs to make decision about accepting minors without parental consent, they should know the relevant statutes in their country. This is informed consent process with minors. Minors are not always able to give informed consent. The APA 2010 provides guidelines on this matter. The first one is for persons who are legally incapable of giving informed consent, psychologists nevertheless provide an appropriate explanation. And number two, seek the individual's assent. And number three, consider such a person presence and best interest and obtain appropriate permission from legally authorized person. If such a substitute consent is permitted or required by law. When a consent by a legally authorized person is not permitted or required by law, psychologists take reasonable steps to protect the individual's right and welfare. From the ACA 2005 also addresses this topic when counseling a minor or persons unable to give voluntary consent, counselors seek the assent of a client to service and include them in decision making as appropriate. Counselors recognize the need to balance the ethical right of client to make a choice, their capacity to give a consent or assent to receive service, and parental or family legal rights and responsibilities to protect this client and make decisions of their behalf. Therapists working with children and adolescents have an ethical responsibility of providing information that will help minor clients become active participants in their treatment. If children lack the background to weigh risks and benefits, and if they cannot give a complete informed consent, therapy should still attempt to explain the therapy process and general procedures of therapy to them. And then even though minors usually cannot give informed consent for treatment, they can give their assent to counseling. Uh, According to Welfare 2013, assent to treatment implies that counselors involve minors in decisions about their own care, and that the greatest extent possible they agree they participate in the counseling process. This is also the importance of involving parents in the counseling process with minors. To work effectively with the minor, it is often necessary to involve the parents or guardian in the treatment process. This also gives the therapist an opportunity to see how the child behave in the presence of parents, and also how the parent react to their children. This policy make it possible to create clear boundaries for sharing information and establish the three-way bond of trust. This is from Lawrence and KBPA 2000. And then the American Psychiatric Associate 2013b offer this guideline. A careful judgment must be exercised by the psychiatrist in order to include, when appropriate, the parents or guardian in the treatment of a minor. At the same time, the psychiatrist must assure the minor proper confidentiality. And then from the ethical standard for school counselor 2010 address the matter of the school counselors responsibilities to parents. Professional school counselor respect the right and responsibility of parents, guardians for their children, and endeavor to establish as appropriate a collaborative relationship with parents, guardians to facilitate the students' maximum development. This is an ethical and legal challenge pertaining to confidential with minors. According to Benitez 2004, counselors who work with the minors are frequently challenged to balance the minors' need to confidentiality and the parents' request for information about the minors' counseling. Benitez claims that it is a wise policy for practitioners to make it clear to parents of minors that effective counseling requires a sense of trust in the therapist. Therapists cannot guarantee blanket confidentiality to minors. If the parents or guardians of minors request information about the progress of counseling, the therapist may be expected to provide some feedback. Ramley and Harley 2014 state counselors have legal duties to parents or guardians or minors, and that is some circumstance counselors will determine the parents or guardians must be given information that a minor client has disclosed in a counseling session. Minor who engage in a self-injuries behaviors raise complex issue regarding the limits confidentiality. This is from Wester 2009. Point out that there is little in the ethic codes of the SCA or the APA to assist counselors in determining when the branch confidentiality for minor who engage in self-injuries behavior. It is crucial to set limitations of confidentiality, especially related to self-injuries behavior at the outset of a professional relationship. Counselors need to understand the distinction between self-injury and suicidal behavior, as well as have the expertise to identify self-injury when it is presented in counseling by a client. One step that counselors should seek supervision and consultation when necessary, so they are working within the boundaries of their competency. And that although minor clients have an ethical right to privacy and confidentiality in the counseling relationship, the law still favors the right of parents over their children. However, some sensitivity information, if revealed or disclosed, may be detrimental to the therapy process. And then disclosure of minors personal information can result in the child no longer trusting the therapist, fearing that this personal information will be closed to parents. This is from Bennett et al. 2001. This should be explained the parents or guardians during informal consent process. And lastly, the parent and guardians usually have a legal right into information pertaining to counseling session with the children, although a court may hold otherwise due to specific statutes. This is from Ramley and Hurley 2014. When parents or legal guardians become involved in the counseling process, counselors must acknowledge that these adults have authority over minors. And then this is a second topic I present. The title is dealing with suspected unethical behavior of colleges. The first one is unethical behavior of colleges. Commission of Rehabilitation Counselor Certification, CRCC 2010, state when rehabilitation counselors have a reason to believe that another rehabilitation counselor is violating or have violated an ethical standard, they attempt first to resolve the issue informally with the other rehabilitation counselor if feasible provided, such action does not violate confidentiality right that may be involved. The number two, National Association of Social Workers 2008, they state that social workers should take adequate measures to discourage, prevent, expose, and correct the unethical conduct of colleges. And that the National Organization for Human Service 2000 stated that human service professionals respond appropriately to unethical behavior of colleges. Usually this means initial taking directly with the colleges, and if no resolution is forthcoming, reporting the college's behavior to supervisory or administrative staff and or the professional organizations to which the college just belongs. Although the ethics codes of most professional organizations clearly place the responsibility for addressing problems of competence or unethical behavior of colleges on the members of their profession. This is from Johnson and College 2012. Stated that mental health professionals are reluctant to address such problem. Professionals admit they might not directly approach colleges. They believe is functioning below thresholds for competence of behaving unethical, even though they have an ethical duty to address the situation. And then professionals have an obligation to deal with colleges when they suspect unethical conduct. Kitcher and Keith Spiegel 2008 recommend informal peer monitoring as one way to assume responsibility for watching out for each other. Informal peer monitoring provides an opportunity for corrective interventions to ethically questionable act. If your effort at an informal resolution and apparent unethical behavior by college are ineffective, you have an ethical obligation to file a formal complaint. This is by Bennett Anna Johnson 2008. Generally, the best way to proceed when you have a concern about the behavior of a college is not deal directly with the college, unless doing so will compromise a client's confidentiality. In cases egregious offenses such as sexual exploitation of a client or general incompetence, informal measures are not enough. Let's say, depending on the nature of the complaint and the outcome of the discussions, reporting a college to a professional board is one separate of option to the counselor. Thank you. This all from me. Thanks for listening. Thank you, doctor, and all fellow friends. To continue our presentation today, I would like to invite our third presenter, Mr. Zulfikri. Thank you.
Okay, thank you, my friend. Okay, I will continue my part for this presentation is about the subtopic is malpractice. Okay, the word of malpractice means the bad practice. Malpractice is the failure to render professional service or to exercise the degree of skill that is ordinarily expected of other professionals in similar situations. Malpractice also is a legal concept involving alleged negligence that result in injury or loss to the client. And professional negligence can result from unjustified departure from usual practice or from failing to exercise proper care in fulfilling one's responsibility. Okay, as a family therapist, especially faith-based counselor or mental health counselor, so you have to handle people at their most vulnerable. Client turn to you for guidance so they can make sense of life's many obstacles and their own limitation. But with the great trust come a great risk. And if client think you overstep your professional boundaries, you could be sued for malpractice. Okay, go for the next slide. This is about the element to succeed in malpractice claim. Okay, the first is all professional relationship between the therapist and client must have existed, and the second is the legal duty based on this relationship must have been branched. The therapist must have acted in a negligent or improper manner or have deviated from the standard of care by not providing service that are considered standard practice in the community. And the third is the client must have suffered harm or injury, such as emotional distress or physical harm, and which is must be verified. Okay. The fourth is there must be a legally demonstrated causal relationship between the practitioner, negligence, and or a breach of duty and the damage or injury claimed by the client. So there are different kind of malpractice charge, but each must stem from a foundation of therapist failure to follow a duty of care. This follow the same basic format as a negligence claim. Negligence charge have specific claim element, duty of care, a breach of the duty of care, causation, and injury. A therapist has a duty of care to a patient. If that duty is breached and that breach result in patient suffering and injury, then a malpractice suit can result. To prove that you have been a victim of therapist malpractice, so the client must be able to show several things. You must be able to show that an ordinary reasonable therapist would have acted with more expert witnesses to establish the standard of care. In other words, you need to show that the therapist disregarded the normal duty of care that a therapist would extend to their patient. Okay, this is about the element to succeed in a malpractice claim. Okay, I will explain about the reason for malpractice suit. Okay, the first is the procedure used by the practitioner was not within the realm of accepted professional practice. Okay, the second is the practitioner employed a technique that he or she was not trained to use. Okay, the third is the professional could have used a more helpful procedure, and also the professional did not explain the possible consequence of the treatment based on the Wheeler and Bertram 2012, and also informed consent to treatment was not obtained or not documented. And lastly is the therapist fail to warn others about and protect them from a violent client. Okay, next. Okay, this slide about the event that trigger malpractice claim against therapy and counselor. Okay, the first is the counselor failure to obtain or document informed consent. Okay, the therapists need to recognize that they can be liable for failure to obtain appropriate informed consent, even even if their subsequent treatment of the client is excellent from a clinical perspective. Although written informed consent may not be needed legally, it is wise to have a client sign a form to acknowledge their agreement with the term of the proposed therapy. Without a written document, it may be very difficult to ascertain whether counselor communicated clearly and effectively to client about the therapeutic process and whether the client understood the information or not. Okay, the second point is refusal counsel a client due to value difference. Okay, the therapist who refuse to work with client due to value conflict may be liable for legal action and malpractice suit. This is because the code of ethics of most professional organizations state that clinicians may not discriminate against specific category of people. If a counselor refuses to work with a client because of value conflict, or if the counselor attempts to impose his or her value on a client, the client has legal and ethical ground to file a complaint to the counselor. Okay, the third is uh, the client abandonment and premature termination. Okay, they define abandonment as the failure of the psychologist to take the clinically indicated and ethically appropriate step to terminate a professional relationship. Okay, a central concern associated with termination is avoiding abandonment of a client. Clinical record should give evidence that they were not terminated inappropriate. It is useful to document the nature of client termination, including who initiated the termination, how it was handled, the degree to which initial goals were met, and referral provided when appropriate. Okay, the first is sexual misconduct with a client. Okay, the related to the topic of unhealthy transference relationship is the area of sexual boundary violation. one of the most common ground for malpractice suit. Okay, this about the event that trigger malpractice claim, and we go for the next slide. Okay, this about the also about the event that trigger malpractice claim against the therapist and counselor. Okay, first, the first in the slide is mark departures from established therapeutic practice. Okay, if counselor employ unusual therapy procedures, they put themselves at risk. They bear the burden of demonstrating a rationale for their technique. If it can be shown that their procedures are beyond the usual method employed by most professionals, they are vulnerable to a malpractice action. Okay, the second is practicing beyond the scope of the competency. Okay, mental health practitioners especially have been held liable for damage for providing treatment below a standard of care if the client follow the treatment suggested by a professional, and the client have suffered damage as a result, the client can initiate a civil action. Okay, professional healthcare providers should work only with those clients and deliver only those services that are within the realm of their competence. Accepting a case beyond the scope of counselors' education and training is not only breach of ethics but also can result in a malpractice suit. Okay, then the third is negligent assessment and misdiagnosis. Okay, negligent assessment can be the basis for complaint to a state licensing board and ethic committee. And for malpractice action, area of high risk is involved assessment in child custody case and its employment evaluation, and also lacking the ability to demonstrate diagnostic competence can result in making a misdiagnosis or no diagnosis, which could leave the practitioner vulnerable to an allegation for malpractice. Okay, this is based on the Wheeler and Bertram 2011. Okay, the first is repress or false memory. A memory is considered false if it is arrived at through an untested intervention by the therapist rather than being the client's actual memory. Therapists have been sued and found guilty of such induced memory. Also, the continue about the event that trigger the unhealthy transference relationship. Okay, the importance of understanding how transference and counter transference play out in the therapy relationship is considered in other chapter. In chapter 2 that has been presented by other group, the mere existence of counterference feeling is not an ethical or legal issue. However, if a therapist's personal reaction to a client cannot be managed effectively, and abuse of power is likely, and this can have both ethical and legal consequences. In case involving mishandling of client transference or counselor counter transference, allegations have included sexual involvement with client, inappropriate socialization with client, getting involved with client in a business situation, and burdening client with a counselor's personal problem. Okay, for the next is failure to assess and manage the dangerous client. The therapy may have a duty to intervene when the client poses a grave danger to themselves or to others. However, it is difficult to determine when a given client actually poses a danger to self or others. Okay, we move to the next slide. Okay, the second is about risk management strategy, and the one of the best precaution against malpractice is personal and professional honesty and openness with the client. Uh, that is the providing quality professional service to client is the best preventive step to you can take. And misunderstanding between the therapist and client can result in stronger therapist client working relationship if the client and the therapist talk through the misunderstanding. Okay. Okay. The second is the additional recommendation for improving risk management is make use of treatment contract that present clients with written information on confidentiality issues, reason for contacting client at home, fee structures and payment plan, and a policy on termination and suicide provision based on the Kennedy at 2003. Okay, the third is present information to your client in the clear language and visual the understand the information. Okay, this is very important. As a counselor, we must talk with the client with the clear language uh, and the and clear language for the clear understanding to the client, or to avoid many misunderstanding that occur during the session. Okay, the first is explain your diagnosis, the treatment plan, and its risk and benefit in sufficient detail to be sure the client understand it and document this as well. Okay, next slide. Okay, we continue again about the second is restrict your practice to client for whom you are qualified by virtue of your education, training, and experience. Refer client whose conditions are obviously not within the scope of your competence. Okay, next is document not only what you do and why, but what you decide not to do in the certain cases. Okay, this is very important also. The first is the maintain good financial and clinical record and recognize your ethical, professional, and legal responsibility to preserve the confidentiality of the client record. Okay, this is also about the additional recommendation for improving risk management. Okay, the develop clear and consistent policy and procedures for creating, maintaining, transferring, and destroying the client record. Okay, the second is report any cases of suspected child abuse, elder or dependent abuse as required by law. Okay, the next is the be especially prudent about informed consent, documentation, and consultation when crossing boundaries or engaging in multiple relationships with high-risk clients. Okay, next is about the do not engage in sexual relationship with current or former client or with a current supervisors or student. This is very important for all counselors. Okay, the next is before engaging in any multiple relationship, seek consultation and talk with your client about the possible repercussions of such a relationship. Okay, we go to the next slide. Okay, get training in assessment of clients who pose a danger to themselves or others, or have experience and competent therapists to whom you can refer. And also the consult when you are working with a suicidal client. Clearly document the nature of consultation, including the topic discussed. And if you make a professional determination that a client is dangerous, take the necessary step to protect the client or others from harm. And next, treat your client with respect by attending carefully to your language and your behavior. Okay, we move to the next slide. Okay, this is about the cause of action in malpractice suit. Okay, the first is treat the lawsuit seriously, even if it represent a client attempt to punish or control you. Okay, do not attempt to resolve the matter with the client directly, because anything you do might be used against you in the litigation. Okay, the consult with your professional organization legal counsel. If you consult with any attorney, prepare summary of any pertinent event about the case that you can use, and also never destroy or alter file or report pertinent to the client cases. Okay, and next also about the cost of action in a malpractice suit. Do not discuss the case with anyone other than you attorney and other than your attorney. Determine the nature of support available to you from professional association to which you belong. And the last in the course of action is, do not continue a professional relationship with a client who is bringing a suit against you. Okay. This is about the legal liability in an ethical perspective. Okay, the legal issue gives substance and direction to the evolution of ethical issue. Okay, also engaging in self-reflection and dialogue with a college can go a long way toward reducing your legal liability and increasing your effort to be an ethical practitioner. And also, this discussion of malpractice and risk management strategy is not meant to scare you or make you overly cautious. And we hope our discussion of malpractice increase your awareness of the range of professional responsibility and suggest ways you can meet this responsibility in an ethical fashion. Okay. Okay, next, for the last part in my presentation is about the conclusion about my group presentation. Is first, the client rights can be protected if therapists develop procedure that aid their client in making informed choice, and informed consent can best be viewed as an ongoing process aimed at increasing range of choice and responsibility of the client is an active therapeutic partner. Therapists have a responsibility to their client, their agency, their profession, the community, the members of their client families, and themselves. The good record keeping practices will help practitioners avoid legal trouble and will enhance the quality of their service to the client. Okay, I think that's all for my part and my group presentation. And okay, if have any question about this topic, you can ask all the members in my group. Okay, that's all. Thank you. Assalamualaikum warahmatullahi wabarakatuh.